Morning. Morning. Welcome, everybody. I'd like to make a couple of announcements before we get started. Please turn your cell phone to silent or vibrate during the program. The information is in the back of the room, in that back corner right there. The certificates for New York and Illinois will be emailed after the conference.
All program materials.
All program materials are available on the division's website at americanbar.org/YLD. Complimentary Wi-Fi is available in all program rooms. No passcode is necessary. Capacity is limited, so please bear this in mind. Please join the conversation on Twitter. The official conference hashtag is hashtag YLDSpring18. If you have any questions, please speak to an ABA staff person or visit the registration desk located on the crystal floor on the third floor. Thank you all so much for being here, and let's get started.
Thank you. Good morning, everyone, and thank you for being here. My name is Beth Palmer. I am an attorney in Charleston, South Carolina with Rosen, Hagood, and I primarily do business and probate litigation, but Bully Proof is a program that I've been involved with for many years with Mario, and something that's very near and dear to me. And so today we're going to take that program and kind of take it to a different arena, which is workplace bullying. I'm going to let our panelists introduce themselves, but before I do so, I encourage everyone to ask questions throughout this program. We really want it to be interactive. We're going to try to reserve some time at the end for questions, but please do ask them throughout. Mr. Spock?
Hey, my name is Andrew Spock. I'm co-managing partner at Baron Liebman LLP in Portland, Oregon. We do management side, employment, labor law, benefits, and higher education. And
Good morning, everyone. My name is Roula, Allouch. I serve as staff counsel for Liberty Mutual through the law offices of Ray Decker in Cincinnati, Ohio. And I also serve as chair of the National Board of Directors of the Council on American-Islamic Relations.
I'm Tom Grella. I practice law in Asheville, North Carolina. I managed that firm for 12 years. I've been with the firm for 31 years. I was managing partner for 12 years. Was on the management committee for 17 years, and just rotated off for good, I believe. I came up through the YLD. I'm an active member of the Law Practice Division, which I chaired about 10 years ago. And I take the Law Practice Division, the Law Practice Division, our mission everywhere we go. So I've got a book that I'm going to give away that we published. It's a $90 book called Lawyers as Managers. There's a chapter on bullying in this book to whoever can answer a question first, and that is, who was the most decorated person in World War II? Anybody know that? Backup question if nobody knows that. Buddy Murphy's correct.
Oh. Did you Google?
Wait, yeah. Did you cheat?
That's right. We just came back from a cruise on the Rhine, and that was one of the tours that we did. It's all about Buddy Murphy, so you can get the book afterwards.
And although he's not sitting at the panel, Mario, will you introduce yourself?
Hello, I'm Mario Sullivan, a past chair of the Young Lawyers Division, and started Bully Proof. So thank you all for being here. It's going to be a great program.
All right, so let's get started. Bullying. Everybody knows the typical forms of bullying: pushing, shoving, name calling, that sort of thing. We see that. It's very easy to see that. But in the workplace, bullying can take a lot of different formats and things that aren't as easy to pick up. So, Shvag, why don't you start on the tape? What is workplace bullying?
yeah, so workplace bullying is kind of hard to define. It's vague. It does sort of go a little bit hand in hand with, hostile work environment or harassment. That's usually sort of the context where you see these types of claims come up is, I think the real answer is, is bullying illegal in and of itself? Not necessarily in most states, but it usually is evidence in the context of a hostile work environment or harassment type case. And so it can take a lot of forms. Usually we think of it in terms of sort of there being a power dynamic, either a supervisor to a subordinate or one coworker to another, repetitious behavior that is intended to demean or make someone feel uncomfortable, unhappy, less interested in being in the workplace than they were before the behavior. But it's by its nature, very hard to define, and oftentimes becomes, you know, a sort of he said, she said type question about, you know, how was that comment made, or, you know, what did that person mean by the statements that they said? So it is difficult to define.
Would you agree that in times, I mean, manipulation tactics, isolation, even the assignment of work assignments essentially, deadlines, I mean, all these things I think can be said to be workplace bullying. Roula and Tom, do you think that the legal profession lends itself to workplace bullying more so than potentially other professions?
Start first. I do. I think it does. Given the context, especially in firm environments where there's partner-associate relationships and different dynamics, interpersonal matters that come into play, and given some of the things you pointed out, Beth, like work assignments and other things that can lead to a more forceful impact on particular people, I think those types of things could, over time, add towards workplace bullying.
I'm not sure if it's the profession itself, but it's the way that lawyers are trained. My experience was that bullying comes out in different ways depending upon the type of lawyer. I had more problems with folks who were in my litigation practice group than others with respect to more difficult public displays of anger. They're just, it's different than the types of bullying that I saw. So I saw a lot of different types of bullying. I saw bullying through things like billing credit manipulation by partners, work assignment, and I want to speak about that really briefly in a second, but also origination credit manipulation by partners. I also saw bullying where a member who was a partner, the way they treated their staff, they didn't treat other lawyers differently, they treated their staff differently. And I think that the way we're trained, where lawyers at one time, this isn't true anymore, but lawyers at one time were sort of a repository of all knowledge about legal things. Now, you know, with the internet, it's changed some. But because of that, it creates this sort of hierarchy mentality, which I represent a lot of doctors as well, and I see this in their profession as well, where they actually think they're better people because of their status as a lawyer, and they treat other people inappropriately. And I saw that not quite a bit, but with different people throughout the years. And then I just had the more obvious things. I had one partner who's no longer with us. It was very difficult. Displayed anger, just inappropriate conduct in so many different ways. He had to leave, but so there's the obvious things, but then there's this manipulation. And on work assignment, I question whether or not that type of work assignment, origination credit, collection credit, those kinds of things are created by the systems of compensation that we have within our organizations. When you are compensating and determining salaries and bonuses so heavily geared towards the short-term annual receipts, there is more of an incentive to do whatever you can to raise those numerics, and that is what, regardless of what your values say on your website, that's what you value, and when you value that, it will create a situation where you have people trying to run over other people.
And I'd agree, you know, particularly in the litigation context, I think one way that I think a lot of young lawyers have seen bullying in sort of their practice is a more senior practitioner sort of trying to take advantage or, you know, push you a little bit closer to the limits in a deposition or in a litigation context to see if they can get some slight advantage in the case and to see, you know, whether if they push you, you kind of shut down. Or I certainly, my first deposition that I defended, I had opposing counsel. I offered my client a glass of water, and he proceeded to call me water boy for the remainder of the deposition. And, you know, it was gamesmanship, I think, on his part to see if, as a result of that behavior, I would sort of object less or just be more compliant with sort of his approach and his tactics. So I think young lawyers and I think diverse attorneys and I think female attorneys, you know, there are often sort of those efforts to sort of get a little bit of upsmanship in a litigation context by sort of bullying tactics.
Yeah, just to follow up on that, especially when you hit on Schwab, diverse attorneys and female attorneys. Unfortunately, I'm not even going to ask for a show of hands, the number of women in the room who have probably been perceived as not the attorney when you walk into the courtroom or into a deposition. Man, it makes me sad to see the number of head nods. And then people from different cultural backgrounds, where people may not necessarily perceive those individuals to be typically what one would imagine would be an attorney, then those types of tactics that you're talking about, I think, are even utilized further to push people into a position where they feel like they are somewhat intimidated because they're coming in already in some level of perception at a disadvantage. The person doesn't have to necessarily feel that, but sometimes the situations force that.
Do you want me to talk ethics real quick?
Wait a minute.
Okay.
I'm gonna ask a tough question. We live,
Oh, no.
we live in a world where everybody gets a trophy. And our profession is tough. You have to be tough to do what we do. So how do you draw the line between bullying and being effective and being, you know, criticized? What is and is not bullying, and how do you draw that line? Anybody?
I guess I'll start that. It is a tough question. I would say, for me personally, I think there were instances where I've been bullied in the workplace primarily because I'm a Muslim attorney, and in my practice area region, there really haven't been many people that look like me wearing hijab at practice. And I dealt very specifically with one attorney who frequently made multiple comments, and I think for me, I had to learn where the line was, where it stopped permitting me to practice and focus on my work, and it became impactful on my emotions and on my kind of abilities to focus on work. And a lot of times in personal experiences, it was when things were built up over time. So unfortunately, I don't think there's like a clear set of rules and guidelines. We learned that with bully proof in some ways outside of the workplace context. At work, I think it's harder, but I believe that there's a responsibility on managers, and they have an obligation to prevent behaviors that lead to people having those feelings.
And I think that segues into
Yeah.
ethical considerations.
And so, you know, oftentimes the way that this comes up in an employment law context is it ends up being a test of reasonableness. You know, objectively, what would someone feel if they were doing it? And the jury is usually the person who's sort of the reasonable person in that person's position. How would they feel if that was done to them? But in terms of kind of the ethical thing, there has been a change to the model rules of professional conduct to specifically address sort of harassment towards attorneys or parties, and that is contained in 8.4G for those of you following along in your respective professional conduct manuals. But basically the idea is, you know, it is professional misconduct now to engage in conduct that a lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status. And so there, once again, you know, we're talking about harassment or discrimination on the basis of a protected category. So, you know, the age, you know, ends up being kind of a harder one to define, but obviously if it's on the basis of being Muslim or on the basis of being a woman or on the basis of being a certain race, that becomes very clearly within that context. And just to provide a little flavor for that, we had a really interesting case in our state where it was a law firm party, you know, a huge firm party where all the lawyers in town are there and probably having a little too much to drink in many cases. And this woman attorney was in a construction defect case against a guy who was the head of his department, the group, at the biggest firm in town that was doing it. And the guy approached her and probably had too much to drink and engaged in intimidation tactics about sort of the deposition they were going to have the following day, sort of trying to push her to, you know, resolve or give up on a case that she was engaged in. And it actually got to the point where there was, you know, physical contact involved in his sort of talking and addressing her. And as a result, she filed assault charges. It became a huge criminal issue. He was disciplined, and I don't know if your states have it, but in our bar journal, what you look at is the moves and the discipline sections, every month. And, so he got written up for sort of the conduct. He lost his position as head of the department at that firm. He's still there, which kind of surprises me. But that actually triggered this rule in our state, was sort of that harassment in this particular environment. So our state House delegates voted to sort of add this type of language, and I believe our state was one of the motivators for the change in the professional rules on this issue.
Tom, as a former managing partner, what can you do or what did you do to encourage people to report bullying, come forward with bullying, and how did you spot it and address it?
So let me talk about myself as managing partner, because Rule 8.4, that was just a provision that you read that was just created. And it was a little controversial in ABA as we debated that and voted on it in the House. And there are words at the end of the sentence which says conduct related to the practice of law, and the comment talks about the fact that it doesn't only have to do with substantive practice, but also management of law office. So I lived with rules. That rule wasn't in place yet, but I lived under the preamble which says that a lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. And then under Rule 5.1, it says, and it's entitled Responsibilities of a Partner or Supervisory Lawyer. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if, number 2 says, the lawyer is a partner or has comparable managerial authority in the law firm in which the other lawyer practices or has direct supervisory authority over the other lawyer and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. And also, Rule 8.3 has to do with reporting professional misconduct, that a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So I lived under these rules as I managed, and I came to the conclusion that there was always a huge pressure to just sweep things under the rug, figure out a way out. And I think one of the questions later on, I'll answer it now because it's relevant. One of the things, like when a staff person comes in and they're like being abused by their lawyer, tendency to say, find another place for them in the firm and move them away because that person's really productive. So I don't want to disrupt their practice. So let's just get them somebody else. But I just came to the conclusion pretty early on that we had to stop doing that. And you really have to address the problem. And as a managing partner, these rules scared me. Because I just have to do that. To tell you the truth, it scares you most in the area of your trust account. When all the partners have signing authority and you're responsible, that's a whole different topic. So.
Let me add one thing to that. So I think that hits on a great point, and you do have to be careful when these issues arise, particularly in the workplace, as to punishing the person who complains, right? It takes a lot of guts to actually come forward with the complaint, and so I always caution HR people and managers within companies, don't shoot the messenger and be a good listener. And it is enough that person came forward with the issue. It is not their job to relocate or be the problem solver once they've brought it forward to you. Certainly it's okay to encourage sort of an open door policy approach where if the person feels comfortable, maybe having a one-on-one conversation with that manager or other person within the organization. But if they don't, reassigning them or putting them in a different department, that looks like retaliation, especially if the person doesn't want to. If they like their job, if they like their team, and you're saying, thanks for complaining, now you need to go over here and work in a different department or on a different shift to avoid that person, that's retaliation, and that's going to be a problem for the organization.
So again, this is a tough profession. So what would you advise a person to do, a junior partner, junior associate, who has a senior partner that has the mentality of, it's tough, just stop being a sissy.
Mhm. I don't encourage anyone to use the word sissy. I do think you have to be careful. I mean, and the danger, to Tom's point, is the idea that you say, oh, that's just how that person is, right? The defense of the equal opportunity harasser, the equal opportunity asshole, for lack of a better term. Worst defense ever in employment law, you know, having to go to trial and say, well, this person's not discriminatory, they're just a jerk to everyone, so that's the reason why they were a jerk to this person in particular. Don't ever have to, you know, that always looks bad to have to throw people under the bus like that in defending a claim. So, you know, I think a huge issue, especially in kind of the wake of the Me Too movement, is to focus more on the role of bystanders. You know, to talk about, it's not just the victim's job to come forward, it's a lot about the culture of the organization. And how the coworker responds when they're around it is oftentimes more important than how kind of HR responds when it's brought to them. Because, to quote this football coach in Texas, you know, culture doesn't change when the coach says, this is how you're supposed to be behaving. Culture change occurs when the teammates say, that's not how we do things here. And I think that's huge in terms of, in any organization, you know, encouraging coworkers to be sort of allies for one another and to sort of, you know, basically stop that behavior dead in the tracks when it occurs.
But also, I would just add to that, it's important for law firms and other organizations that are hiring attorneys, but speaking specifically about maybe even smaller firms, many don't have HR procedures, policies, they don't have HR professionals either in-house or that they can reach out to. And I think in the increased information we have about implications of bullying and harassment and other things, the mental health issues that are coming as a result, the really serious actions that sometimes are occurring, law firms need to be encouraged to seek professional help in terms of management of their law firm practices. Being a managing attorney because you have the highest caseload or the most number of clients, that doesn't mean that you're a good manager in terms of HR and interactions with individuals and dealing with people that are complaining about harassment or bullying matters. So I think culturally too, we need to shift from law firms and their values being focused specifically on money making, which I understand is business at the end of the day, but it ultimately will benefit the bottom line if HR policies are in place to protect against these types of things.
And it really does. I mean, if you look at just sort of the numbers, there's a business case for being against bullying in terms of attendance, how many sick days someone takes, sort of their longevity with the organization and the replacement cost of finding someone when someone leaves because of the treatment they feel they're experiencing. So even if you're kind of running up against that hard wall of people who just think economics, you can make a business case for sort of how the treatment of others impacts the bottom line of an organization.
I think Tom probably has something to add. I mean, we've talked about the legal, ethical implications of bullying and seeing it going on and not addressing it, but what are some of the other implications of bullying in the workplace and how it affects the business?
I was gonna add to the last question.
Go for it.
The question was from the person who's being bullied, what do you do? Do you you know, advise someone? Do you go to someone and complain? I think the first question to ask is, what are the values of the organization? And I wouldn't go to the website to find out what they are. You know what they are. You know what leaders of your organization value. And if going to the leaders of the organization with whatever those values are, you know, it may be a waste of time. You have to ask yourself whether or not the values are ones which will support the complaint. Will the complaint be investigated or will it be swept under the rug? So I think back to my firm 18 or 19 years ago, and I learned a whole lot from the managing partner who managed our firm for 30 plus years before me. And he's a great mentor in management, but we didn't address a lot of situations. And so I was thinking back, you know, when an issue like that came up, he managed it. He didn't address it. And there's a difference. And that led to a lot of things that needed addressing. When I became managing partner and realized this wasn't the way to operate for the future success, the organization's success. So I would say that if you're going to stay in the environment, if you're going to stay in the environment, you decide, I'm going to stay in the environment and do best I can, but but those values don't exist, I'd start taking notes of everything that, everything that occurs, when it occurs, because at some point in time, you're not going to be able to handle it anymore. But the better thing to do is probably to decide whether or not you want to be involved in that situation. If you're not going to be able to, you can take on the situation and become the catalyst for change, but you have to decide that you want to do that. And that can be very distressing to your being over a long period of time. So you need to take care of yourself physically, mentally, emotionally, because it's difficult.
And there is, a legal claim basically called constructive discharge, just the idea that if you quit because no reasonable person under the circumstances could stay in that work situation, it's treated like a discharge. So just because someone quits as a result of bullying or harassment or mistreatment doesn't mean the company is off scot-free and they can be like, oh, great, that person's finally gone. I can not have to deal with that complaint and just go on with its manager. You do have to be aware that if you're supporting or, not addressing those situations, that it can constitute a legal claim even if the person quits.
Can I make one final comment?
Absolutely.
On the question of, because I was reflecting, you asked the question about stop feeling you should deal with it, don't be a sissy. But I think that attorneys, we all have to take our responsibility for our part in allowing a culture of, well, it's challenging to be in law school, studying for the bar, being a young lawyer, suck it up, I did it, you should be able to do it too. Because each person's experiences and the perception and perspective that they have, that they bring to the table may be different. And, it's one thing to say, well, I went through a difficult partner-associate relationship when I was a young lawyer, but each of our circumstances are different, and different people's interactions, they vary, how people are perceiving what's happening. So I just think it's important that we all take ownership in the need. I was really, happy to see the change, and I participated in the debate. I know that at the House it was certainly something that was contentious to some degree, to make the change to Rule 8.4, but I think we all need to own our part in what's happening in the legal profession and making sure that we safeguard it and protect it from further bullying.
Can I add one more thing? I think that raises a great point, and one of the things that we definitely see, and some of it may be as a result of sort of different generations in the workplace, but a major way that this has been popping up, particularly in law firms, is woman-to-woman bullying. Frankly, sort of a more senior partner to a more junior attorney, particularly if there's parenthood involved. You hear those war stories about how someone was taking a work conference call the day after they delivered their baby, or they came back to work a week after they had their kid, and there's this judgment about taking maternity leave or about having a modified schedule and the like. And you do have to be very careful. Being a mother is a protected status in many ways, not just based on gender, but in other ways. And that does come up. But I think there is a line, and, this is something that firms do have to think about, to the point about the bottom line. It is okay to say, you need to bill 1850, that's our expectation of attorneys here. And if you can't do that, well, then it's not going to work out. Having legitimate business expectations as to sort of productivity of an attorney is one thing. You just have to be careful about when it becomes personal or based on a protected category.
So as young lawyers, I think a lot of us typically have support staff members who are older than us. And, I'm not really a young lawyer anymore. But, first starting out, I would I would feel uncomfortable asking sometimes a support staff member to do something. So do y'all have any tips for young lawyers how to manage people effectively without crossing that line?
The easiest thing I can say is to be respectful. That's the most important thing. Everyone's there to do their job, and I think a lot of times the support staff and people that are serving in different administrative roles, they know their responsibilities and they actually want to fulfill them. They want to work with you. But I think a lot of times when a young lawyer comes in, each side is kind of feeling each other out, like, how are you going to be? But if you come from a place of respect and respecting the role that person's going to play in your practice, and by the way, as a young lawyer, they probably know more than you do about what you need to do that day. So it's not only is it the right thing to do to be respectful, but it's in your own interest to operate in a manner that you can ask and you can delegate and you can manage, but you do it in a way that's always coming from a respectful standpoint.
And what I would add is, Shada is actually very good at this at our office. Don't worry about asking. ask the staff person, what sort of support do you provide to the other attorneys that you work with? What are sort of the ways that we can kind of work together and make this easy for both sides? To Roula's point, usually they are pretty eager to please, but it is an awkward dynamic. I mean, it's probably the first time that a lot of us are actually directly sort of supervising or having someone, and that age dynamic does come into play. And it differs from firm to firm. Like at our firm, you wouldn't ask someone to go get your dry cleaning or go get your coffee, who is a support staff member. But at other firms, maybe it is. So talking to other people in the office about sort of how do you use your support staff to maximize efficiency, and then talking to the actual person about, best practices, what they do, that's sort of what I suggest.
So, I think the key is the word empathy, and we were talking about this a little before the session, about, there's different types of people. Some people don't have the ability to empathize at all, and that's a problem. But to put yourself in the other person's position, and I think you all just had a session on emotional intelligence, and I've spoken on that to the tech show. I spoke on that, and I've written several articles about it. But this whole idea of self-awareness, of kind of figuring out and training yourself through education in emotional intelligence, how you come across to others. I had this is interesting. I had a problem with a partner who is still with us but has changed his conduct. He used to have the one staff person that he primarily, the firm allowed him to use this person primarily as his staff person. He had colored balls that he had her put on the monitor, and each one meant that she was in a different location in the building. And nobody else did that. And it's like, if she was in the bathroom, she had to put like a red ball up, and if she was down on the first floor, she had to put a blue ball up, and it was so ridiculous. But we actually, and we haven't gotten to this yet, but we have a process by which we address these problems with, which has worked for us. Either the person will end up leaving, or the person will remediate, and he has changed his conduct. But through that process, he became a little bit more self-aware about how he came across, and how he was treating other people who he felt. And this is one of the people in my firm who had an issue with this hierarchy. Like, I am actually a better person than you because I have all these degrees in education, et cetera.
How did you address that? I mean, the very first, how did you go about addressing this person, confronting him, and dealing with it?
Yeah, so way back, I came up with this procedure, and I've written a column about it in Law Practice magazine.
Which is in the written material. The column that I wrote was, when I wrote that column, I was thinking about a different remediation, but we went through the same process with this partner. We first confronted him with the issue, the management committee did, and had a discussion with him, told him that his conduct had to change. And I'll tell you this, I said this when we were talking earlier before the session began, it is really, really difficult to change the inner being of someone who's 55 or 60 years old. But we insist on conduct changing. We can't assure that their thought process and their ethics and everything internal, we can't be sure that changes, but we do insist that conduct changes. So we talked to him about that. And for him, we put him on a remediation plan where a senior partner, the former managing partner, was to oversee his remediation, which included some treatment, which he agreed to. So that one worked. We've had others that they rejected it and left, and that was the best thing for the firm too. So
what do you mean by treatment?
Well, so there's two different treatments that we've asked that folks agreed to. And one we can't really, follow up as closely, and that is psychological treatment. But the other is that we've had several instances where they simply needed some malpractice management coaching. And there are consulting companies out there. I believe one of them, Jerry Riskin at Edge, did a really good job for us helping this person. Jerry's a good friend of mine. I asked him to do it, get it everything straight because he's really expensive. But it worked out, and the conduct changed, and he was able to keep up with the things that were causing him to actually bully other people were practice management things. So each person's a little bit different. Their conduct is happening for a different reason, and you really have to dig and figure it out.
You've talked a lot today about how you react to these problems and how you remediate them, but what about proactive? Do you ever have such an individual, for example, come and do training on law practice management? What do you do proactively?
Different questions you're going to ask, right? I need to get back to my notes on that.
Well, yeah, I think that's a good point. How do you foster an environment that encourages people to come forward and say, I'm being bullied, or I have seen bullying? What, as a managing partner, do you think fosters that type of environment?
Well, I mean, I think proactive training is one way of doing it, even though it's like the dreaded hour and a half of hearing from someone else talk about all the ways that we need to ensure a better culture. I think it's a way of putting your money where the mouth is, trying to figure out how you say that. I mean, it's a way of sending the message that we care about this, even if it is sitting around and having a training. I also think one of the things we do within our firm is, sort of establish a number of mentor relationships with people. So, we don't just have a new attorney have a partner mentor. We have, the associate have an associate mentor, a staff mentor, and a partner mentor, so that there's as many communication channels as possible. Because, one of the things we found, we've got an executive director who's an attorney, but is not practicing, Tracy Ray. She's involved with the law practice division. And, what we've found is that oftentimes she's the person that people feel most comfortable going to. It's not necessarily going to be the person that you plan for, and so you have to be aware that, different people are going to feel comfortable going to different people about those issues. And the biggest thing is to be a good listener, make sure that communication gets to people who can make a difference about the issue, and get out in front of it. Because I think a lot of what happens is, if you build a culture where people know if I complain, nothing happens, or that person is untouchable because they're so valuable to the firm, people are going to stop complaining, and those issues are going to continue and perhaps, fester with the lack of action.
So, we actually have two questions, and I guess we'll get the other one soon, but the question is sort of tips for preventing bullying. And I mentioned this earlier, and what we did at our firm was we, over a 12-year period of time, we changed our compensation system. I thought, after looking at it for a while when I first came in, that our very, very objective compensation system was hindering the future of the firm, was really an obstacle to positive growth in so many different areas. We had a system which looked at numbers, all numbers, and a very small percentage subjective. It was sort of like a little bit of this pool to kind of, it was supposed to be for subjective things, but what it ended up being was an amount to keep somebody happy who ends up being ticked off that they had a really productive year and won this year, but the prior years that went into this formula kind of hit them hard that year, and they were expecting a bonus. And it wasn't positive, because when you have everybody focusing on numbers, you're not having anybody focus. They say they are, but they're not focusing on the future, and they're not focusing on how to deal with other people that much, because they're focused on getting their numbers up. So by changing that to coming up with a value statement, which we hold ourselves accountable to, we have changed the culture. And when you change the culture, you change the way people treat each other. And that's what our experience
And I'll generalize, I think that's huge, and, you know, you're exactly right that whatever the compensation equation is gonna be, people are gonna game it as best they can to maximize those numbers, and at the expense of perhaps sort of personal dynamics. You know, one of the things that we often talk about in talking with employers is, you know, think about sort of the times that you've had conversations with these people when you're making advancement, promotion decisions as well as compensation decisions, because, you know, you'll have these cases where someone was accused of misconduct and substantiated in terms of harassment or bullying, but then you look at their evals and their compensation history and they got, you know, 3 out of 5 or 4 out of 5 meets expectation type reviews and, you know, salary bumps every year, and sort of like, well, what message does that send as an organization if this person isn't being dinged in a financial way for the behaviors that they're exhibiting in the workplace?
Do y'all have any personal examples of being bullied yourselves in the workplace?
Yes. I'll start and speak to that. So maintaining some degree of confidentiality, but I had experiences where, and I think separating myself out from this, just speaking from a cultural or protected class status perspective, I think a lot of times attorneys from different backgrounds experience many challenges at firms that people from other races or backgrounds don't. And a lot of times it comes into play in somewhat passive-aggressive ways. There's some blatant, outright, like, horrific things that are said, and I've had that happen to me in different instances, work and otherwise. But I had one particular situation where there was a partner-level person at a firm I was working at who repeatedly made comments and jokes. They were not funny at all. But I had a lot of difficulties, and I was challenged in how to handle it. I was a younger lawyer. I think I would handle it differently now, kind of owning some of my abilities. But when I was younger, I think it was a little bit more challenging to stand up and address it. However, I did, because the jokes got to be too much. It was every single day. It was a comment or a joke, most often about my headscarf. And it would be something, it could be as subtle as, like, always pointing out the color of it, but, like, every damn day, like, every single day. There were multiple instances that I could give examples of, but for purposes of the discussion, I think what I would offer is that it took me a good amount of time to know how to handle it as best I could, and as much as I respect and appreciate many of the managing attorneys that were in the office I was at the time, they protected me from the sense that they felt that they weren't allowing me to have any negative employment action, like I wasn't suffering in terms of work that I was getting, bonuses, like the financial structure, all that was not being managed by this individual. So they were saying, well, you're okay, trust me, we know he's like this, but it's not going to affect your work. But it was affecting my work because it was affecting my mood and my ability to, even just my state of mind at the firm. And it was a smaller firm. There was a nepotism issue because the person was related to one of the founders of the firm, was his father. And it continued for a very long period of time. And I tried to handle it different ways, and I spoke to different people about it. And it didn't stop. And finally I reached the point where I realized that the partners that I really appreciated, respected, and loved working with were wanting to offer me a partnership. And I was thinking, well, but I can't be a partner with this dude, because while you guys are all comfortable, not this guy. I pointed to my left accidentally.
Thanks for not pointing at me.
I would be honored to be partners with him. But in the sense that I knew I wasn't going to permit myself to be in a partnership level of an organization that would allow that kind of behavior. So I kind of saw the writing on the wall and tried to remove myself from the situation, because I knew that firm's culture, unfortunately, as much as I loved and appreciated much about them, their culture permitted it to happen over time, continuously. And there's more I could say, and it probably crossed the level of bullying into harassment and discrimination and other matters, but it started with bullying, and I think the note to take away from that for other managing attorneys, maybe in this environment, or they're hearing this session, is to say, if you can stop it at the bullying level, it would prevent it from getting to the discrimination and the parts where you're now really open to liability.
Yes, but one partner who's no longer with our firm. It's really interesting. He came to the firm before I did, and he made partner before I did, several years. And before he became partner, fine. I mean, he didn't display the, especially the anger. After he became partner, it was like he just changed. And I was sort of, someone who yelled out quite a bit in public at one meeting where everybody just kind of got up and laughed because they were like embarrassed for him or something. It's like, it wasn't addressed. It just, people just kind of walked away from it, turned their back to it. Then when I became managing partner, and I'm sure I wasn't his selection. We had two really leaders of influence who decided, it was really because of my involvement in the law practice and management section at the time, they came in and they said, you're it. And we decided you're it. Because the one who had been there for 30 years, he was stepping down. He's going to retire in a few years after that. But it stopped. And it's because, I believe, it's because he sort of, at that point, knew that I was an authority and he needed to actually, and did, fully direct it towards others, because I had some influence now. I was going to gain some influence over, his future. So it stopped.
So everyone here, does anyone have any personal examples of bullying, or have you seen bullying in the workplace? How has it manifested itself? Anybody? Someone out there has to have had
There's a
some
hand
bit,
up.
yeah.
Well, so not exactly. I'm actually a plaintiff's lawyer, and I do employment litigation, specifically discrimination. And so I've seen it in a number of different cases because I'm litigating them. And I actually had a question for you all. How do you draw the line between bullying and discrimination? Really, you kind of touched on it a little bit. But, like, I have some clients that have kind of mediocre cases, right, for discrimination under the various statutes. And then I have some that are, like, really in your face. And obviously, it's usually in the employment context among colleagues. So how do you, and I think, as you may have made a comment, kind of if they had managed it, at the outset, it wouldn't have gotten to the point of discrimination. So how do you all, and what's your advice for kind of recommending, or advising, even if it's your colleague coming to you confidentially saying, well, I feel like I'm being discriminated against, or I feel like I'm being bullied. How do you draw that distinction between the line of harassment and bullying to the point of discrimination? Because obviously, if there are differences in protected characteristics in an average action, you can say, okay, this looks like it might establish a prima facie element for discrimination. But of course, it's the same, even if you're the same gender, same race, whatever, you can still be discriminated against by someone who's in your same group. So how do you all kind of draw that distinction? Are there any tips you give?
You want me to start? So, great question. I think it's very difficult in terms of where that line, is, to be perfectly honest. And, oftentimes, at least from a legal standpoint, it does matter if it's because of a protected category. So, if it's just a jerk, and that person is a jerk to everyone, going back to the equal opportunity asshole, that is something that you're kind of stuck with, and technically it is a legal defense, even though it's a crappy one. But, I think the other part of it is, the reasonableness test. You're often going back to sort of what would a reasonable person under the circumstances feel or say or think if they were subjected to that treatment. And oftentimes what I run into is organizations whose defense is basically, well, that's how things work here. I've represented paramilitary organizations like police and fire departments. They're pretty hard on each other. And what you kind of need to coach them on is the idea that just because that's how we've always done it or that's how it works here, does not mean that's how a jury is going to think it's okay to treat people. And so you often need to encourage people to sort of take a step back from, their environment, same thing with investment firms, very go-hard type industries. Just because their industry is that way is not a defense. And, your jury is going to be not a bunch of people who work in that same industry. And they're the people who are deciding, is that offensive, is that unreasonable, is that excessive? And so I often encourage people to take a step back and think beyond sort of the walls of their organization about sort of how people would think. But I think that line is a very gray one in terms of, when it crosses the line.
Yeah, I think it's gray, I agree, Andrew, but also, from the perspective of someone that's within one of those protected classes or a minority, oftentimes, even the things that aren't blatant or aren't outwardly as obvious to anyone else, the reason being for the comments or the jokes, et cetera, more often than not, what the real reason is. Like, you get the sense of where a person's coming from, but it's hard to translate that into an action, particularly a legal action getting all the way to jury, because unfortunately, these types of cases are very difficult to bring, as people that handle it, especially on the plaintiff side, know. So another part of this conversation, I think, has to be, as a society, recognizing and understanding that there are passive-aggressive or smaller, nuanced ways that a member of a protected class can be impacted. They might not be able to blatantly point to something. Like for me, I'm telling you all, I was harassed and the guy was commenting on my headscarf. Like, that's pretty obvious. But more intelligent people may not do it that way. So, you know, we just have to be mindful of being a society that's ready to handle those more nuanced issues that people are dealing with in the workplace.
And, you know, I think going back to your point, so one of the ways that this often rears its head is sort of, you know, work assignments or else,
Micromanagement.
targeting, sort of excessive scrutiny of work. I mean, I had a case, and it was a horrible case, so we resolved it, obviously, very quickly. But it was a case in which, you know, it was an older female African-American worker who was a janitor. And, you know, the manager was, you know, had a military background, very tall, very intimidating. You know, he just came across as intimidating by nature. And, you know, objectively, his position, you know, I'm just sort of saying what he thought he was coaching this woman on how to clean toilets better, right? But how did that rear itself? You know, literally, she is on her knees in a toilet stall cleaning a toilet, and he is yelling at her about how to do it better. And that just is ugly. And it, you know, whether it's bullying or discrimination or harassment, that is unacceptable behavior. And so I think we do also have to encourage people to understand sort of their frame of reference. I mean, I've gotten flack for this before, but, you know, people who come from sort of certain, you know, I'm going to pick on this guy again, you know, I think that his military background resulted in him being louder in his tone when he talked to everybody, and he, you know, had a much more aggressive sort of posture than sort of your average worker. And so we need to be aware of sort of the dynamics. I mean, Shada brings it up when she does trainings that she's a little bit shorter. So conduct, you know, close talking, stuff like that, it comes across differently based on sort of your physical appearance and sort of how that matches up with the person you're talking to. People need to be conscious of that.
So for all the young lawyers here, say your supervisor, your managing partner, the one that controls your work assignments, controls your compensation, is bullying you. What do you do?
I think we have to reach a point where we start speaking up. I mean, we found ourselves in the position that we're in because I think too much of that behavior has been identified as permissible, you know, getting through the difficult times early on in the associate years so that you can build yourself up as a firm. But what we've seen, the statistics about mental health issues for lawyers and problems that lawyers have, I think stem in large part from bullying and the issues of the harassment that they're dealing with in the workplace. So we have to create environments and situations where people are comfortable to speak up, even though it's a very uncomfortable and difficult thing to do. It takes a lot of courage, whether you're the one person in a firm or a group of people together speaking out on one person. It certainly takes an element of courage, but unfortunately we need those people to be courageous to step up so that these issues can start to be addressed head on.
Yeah, I guess what I would, so in an ideal world, if the person felt comfortable, you'd like to sort of imagine a situation where that person would sort of flag it as it happens. You know, it's a little bit easier to remediate when you have a very specific issue or example that occurs. So, you know, and I think an important practice, particularly in the legal context, is to sort of separate the work-related concerns from the way that they're being communicated or handled, right? So, you know, I understand that you are unhappy with that work product and I'll improve in the future, but I don't appreciate the way that you're, you know, talking to me about this in this context. So separating those out if able, but as we were talking about before, you know, it is not fair to, you know, force the victim to now go back to the person that they feel, you know, harassed by, to sort of now put themselves in front of them again and subject them to that. So I think having a number of different communication and reporting channels is ideal, because, you know, to your point, if it's the managing partner, that person, you know, that victim may feel pretty powerless. And so having other people in the organization, whether it's HR, whether it's a different partner, whether it's a staff director, whoever else, people that person has a better and more comfortable dynamic, feeling like they can go and understanding that it will be addressed without the victim having to do the remediation if it's brought up.
Tom, do you have any tips for young lawyers on confronting bullies, or at least addressing the situation if they're being bullied?
Yeah, so I mentioned before that, and I heard the last two answers, and I mentioned before that I think in an ideal world, the answer is, yeah, we need to speak up. You need to speak up. But I really think that you need to look at the organization that you're with and ask yourself whether or not you're in the correct place for you. I went to law school not to go to a law firm and then become sort of the main guy who makes all the changes. And I ended up being that guy. But had I been in this environment and say I worked for a really large law firm for the first year out of law school and didn't leave these types of issues, but say I was in that situation now and I was being bullied, I would ask myself a whole lot of questions about whether or not it was, my mission to try to make change in this organization, and how I would find a different organization to work for. I would say also something that I didn't bring up is with respect to the specific person that's bullying you, the question of whether or not to speak up is really answered to speak up to that person now, or to go, actually speak up to that person, the type of person that you're being bullied by. Because I think and Goldman writes about this in his book Focus, he actually uses an example of a member of a law firm who is so intense, so focused, he calls this a pace setter, that they pretty much run over everybody in order to accomplish tasks and be successful. To that person, that type of person, he makes the case for being so focused in one thing that they lack self-awareness, and making that type of person aware of the situation might be worthwhile. But he also talks about in his other book, Emotional Intelligence, that there are some people who, and you think of criminals when you think of this term, but are sociopaths or psychopaths. And it's not always a criminal, but it's someone who has an inability in the area of empathy. And if you're dealing with that person, you're probably wasting your time, unless you're like a trained professional in, psychology or something, which I'm not. So it's difficult to answer because it's really case specific.
We've only got a few minutes left. Are there any questions?
So I do HR defense also, and we get asked a lot, hey, do we need to have this for our clients? But we have some law firm clients. We've asked, do we need to have a workplace bullying policy? Of course, HR, everybody wants a policy for everything. And we've actually advised no, because of the difficulty of defining what constitutes bullying. It's a black and white term. I didn't know if any of you have had experience with trying to put into place a procedure or some type of process for your clients or your firms or anything like that, because there seems to be a desire for that, but it's also a very nail and tailor to the wall, depending on who you're talking to, not to mention the sections of the rights issues. So
It's very difficult. I've represented school districts in the past and written bullying policies for schools, and it is nearly impossible, and especially when there's a zero tolerance type of policy, it can be very unfair and then very also ineffective at the same time. But in the workplace setting, what would you say, Scott?
Yeah, so worth checking out the written materials because they're awesome, and because they actually have, Washington State has a definition that they use, and so that's kind of handy. But I think, it's hard to imagine it as sort of a standalone policy. I would sort of think about it as, are there tweaks we need to do to our anti-harassment policy? Because they sort of go hand in hand. And so that would be the place where I put it. And I also sort of think about it in terms of the open door policy. If someone feels like they're being wronged in the workplace, you want them to come forward about it, even if it's not technically a violation of law, right? Because it goes to culture, it goes to sort of longevity in the organization. And so encouraging people to talk if they have an issue.
Well, that is all the time we have. Thank you all so much for attending, and if you have any questions,
Yeah, thank you. Self-identify.